Tivashini and Shobha, two of the subscribers to this channel, asked me to speak about pleadings. I've already done a detailed video on pleading. What I'm going to do now is something I haven't said before, but these are major points. It will be a good idea for you to think about it. The first thing that you do when you're going to do a pleading is listen to your client, study all the evidence you can get your hands on first. Don't jump into anything, don't start drafting, wait. After you've done that, pretend that you're at the end of a trial and draw up a draft end of trial summation or submissions or speech, as they call it in different parts of the world. That will give you an idea of the case that you have against the other side, the case the other side has against you. It'll give you an idea of wholesomeness, where you're going, what you're supposed to do, what you should ask for. Then think about the next most important thing, which is the court in which you are going to file your papers. Some of the relief that you're asking for may not be given by the court because it may not have jurisdiction. So you must think about the court. That's very important. If you file a paper in the magistrate's court, you must ask yourself whether a magistrate has empowered to give you an injunction. Can you go to a magistrate's court and get an order for divorce? Think about that. The second thing that you have to think about is you first decide what relief you want. So when I am doing a pleading, I will not worry about the body first. The body is the beginning of the pleading, the center of the pleading, and the tail of the pleading. I will only concern myself with the tail end of it. What is the relief I'm going to ask the court at the end of the trial? If I'm the plaintiff, the first thing I want to do is I want to first ask for a declaration of my rights. Almost everybody forgets it. If you are doing a breach of fiduciary duties, or if you think the defendant is a trustee, then ask for a declaration. We ask a declaration that the defendant was constituted a constructive trustee of the beneficiary in relation to this property. Then ask for another declaratory order that regulates your rights. Then ask practical orders that will make that declaration into concrete results. An order that the defendant render account to the plaintiff of all accounts, all monies received and all monies expended, and the location, amount and nature of the assets of the estate. Then ask for injunctive relief. If you are asking for an injunction, say so. You might ask for receiver and manager to be appointed over the property. Then you have to go and study the rules of court in relation to receiver and manager and make sure that gets there. The law will say if you're going to appoint receiver and manager, there are certain preconditions, trigger points that you have to clear. Clear those trigger points. Then think about discovery. If I'm going to ask these documents and this guy has got all these documents, I need all those documents. Think about discovery. Okay, if I don't ask it in the statement of claim, I have to ask it during interlocutory proceedings. Put that in mind. If you're asking for documents, what should you ask for? Think about third parties. In the old days, we used to call it a Norwich Pharmacal order. When a person who's not a party to an action is in possession of documents, without making that person a party, you can make an application, serve it on the third party, and demand that person renders documents to you. It's an exception. I think in the year 2012, they included a new rule that deals with this. Now you can expressly go and ask for the document. Think about those things. So then think about costs. Most of you will ask for legal costs and then you stop. There's one more thing you have to put in. Costs, interest on the judgment sum, and finally interest on the costs awarded by the court. Because there is a federal court case and a provision in both the rules as well as in the statute that says you are actually entitled to interest even on the costs which have been unpaid. So sometimes when order of cost is made, the defendant won't pay. He will take 5 years. You can ask for interest. So think about that. So go in right there, 5% interest per annum on any cost awarded. So if the judge says, I'm awarding you 100,000 costs, if it takes 5 years, imagine 5% over 5 years is 25% of the 100,000. You get extra 25,000 on the costs over and above the judgment sum. That's a lot of money. And that also helps you to cross the quantum barrier in bankruptcy when you're going to go for bankruptcy against the defendant. So think about these things. So these are the practical points I want to speak to you about pleadings. I hope you like it. I hope you find it useful. Please write questions down below in your comments about issues that you want me to address. Whenever I have a few minutes free and someone is available, we'll record something for you. Thank you very much. Stay home. Don't go out. Put on your mask. Goodbye.